The first case is Boler et al. Versus City of Rittman. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies here. You can refer to them by initials or terms like the child. We've read your briefs and we're prepared to proceed when you are.
Good morning. May it please the court, my name is Danielle Rice and I represent appellants Tara Boler and Trista Weiss. I'd like to reserve 3 minutes for rebuttal. It's undisputed that from 2008 to 2022, the city of Rittman overcollected millions of dollars of municipal income taxes from its residents due to an error in interpreting its 1977 tax levy. Rittman alleges, although there's been no discovery on the issue, that it determined the error of the 1977 tax levy in July of 2022. It then informed its residents in January of 23 of the error. And there's been no discovery into why there was that delay, but we can only presume it was to take advantage of what it now says is a statute of limitations issue to prevent it from having to repay as little money as possible. So why are we here today? The trial court made several mistakes. In a 3-sentence order with virtually no analysis, the trial court granted the city's motion for summary judgment. And in that order, what it didn't do was it didn't consider or address futility or factual impossibility, nor did it address any of the equitable claims that the appellants had raised.
So are you requesting that we remand this for the court to explain?
No, Your Honor. The request of appellants is that the decision be reversed, it be sent down back to the trial court for discovery to proceed normally. This was a premature decision.
So you want us to review it de novo and reverse?
Motions for summary judgment and decisions of summary judgment are yes, de novo. And if I could just briefly address kind of both of those issues. Although the trial court didn't say so, it just sort of said plaintiffs are unable to proceed under 27-2301. What the city argues is the reason it found that is because of a failure to exhaust. So under 27-2301, the statute requires that a resident at the time of paying its taxes must file a written protest or a notice of intention to sue. So under the city's argument, in 2017, a Rittman resident should have filed a notice of intent to sue based on this misinterpretation of a 1977 tax levy that no one knew about. So that is factually impossible.
Well, they didn't. We know they didn't do it.
Correct.
Not factually impossible. They could have. They just didn't.
Well, to be able to file a notice of intent to sue, they would have had to know of the error. And they weren't told of the error until January of 2023.
So in every case there's something illegal. Is it a requirement of the city to say we've made this mistake, to tell them when they don't even know about it yet? I mean, where is it? How does the city know? I mean, I know that's a discovery issue, but clearly your people didn't file anything.
That's correct, Your Honor.
And there's no discovery dispute about that. Your client said we didn't file anything.
That's correct. There's no dispute on that. The dispute, Your Honor.
When you filed your complaint, you were trying to proceed under 718.
Correct.
Did your complaint even allege claim under 27, 23, or 27?
It did not, Your Honor, no.
When the Spittler case came out and the Supreme Court said, sorry, you can't proceed under 718, maybe there's something under 27, did you amend your complaint then to say you're not proceeding under 27?
No, Your Honor, we did not.
So at this point, you're not proceeding under 27. You're proceeding under 718 and record claims. I appreciate the court didn't rule on record claims.
Correct.
But as far as Chapter 27 claims, you don't have a complaint for them.
We did not plead a complaint under 27-2301. That's correct.
So why would the trial court even have to say you can't proceed in 27 when you haven't filed an action?
Your Honor, I think that's a fair point, and the appellants continue to believe that this is appropriate under 718.12. I recognize what this court said in Spittler. Appellants.
Well, the Supreme Court, we didn't say anything in Spittler. The Supreme Court said in Spittler.
Exactly.
They said what they said.
in the writ of prohibition related to the jurisdiction. They did say RC 71812 does not apply. That, in the appellant's point of view, decision wasn't necessary to determine the jurisdictional piece, but appellants continue to believe it should operate under 71812. That is the statute, the more narrowly tailored statute that deals with municipal income taxes. There's not a single case cited by the city that has municipal income taxes involved in 272301. But even setting that aside, and if it is the position of this court that, okay, there is no valid 272301 claim because it's not pled in the complaint, to your point, we did proceed under 718, this still leaves the equitable claims, which was not addressed at all. And the Ohio Supreme Court in Spittler expressly left open the possibility. There was no mention of equitable claims, and under Ohio law, it's pretty clear. Equitable remedies are appropriate when there is no adequate remedy at law.
Don't we have some cases, Ryan from Supreme Court and some of our sister jurisdictions have said that 27 is the exclusive remedy for these types of tax claims?
The type of tax claims that were heard in Ryan, maybe, but this is a completely different case, Your Honor. If I may briefly, Ryan v. Tracy involved property taxes, as do all the other cases, honestly, under the 2723 framework. In those cases as well, there was no argument in Ryan for equitable remedies. And what our position is in this case is equitable remedies are appropriate because the statutory scheme doesn't provide an appropriate remedy in light of what may or may not have been bad faith by the city.
Is 27, that's an interesting point on the other one about property, this is income tax. Is there any language in the code that would indicate they were only talking about property taxes in chapter 27, or that they weren't, and there would be equitable claim that existed outside of the statute?
Well, 272301 is titled Jurisdiction of Courts of Common Pleas. It's a broader statute. Okay. And then, 71812 is titled Civil Actions to Recover Municipal Income Taxes. The only case that I think either party has been able to find that involves sort of this municipal income tax overpayment is Laborde v. Gahan out of the 10th District. That, of course, applied 718, not 272301. But the point is that equitable remedies under Ohio law, long-standing Ohio law, exist if the court finds that statutory remedies are inadequate. That's the App.No case that we cited in our brief. But there was no finding at all. How did the trial court determine that the statutory remedies were or were not inadequate? There was, again, no discovery into the amounts that were over-collected over the 15-year period, what the city knew and when. Why did they wait so long to inform their residents? Were they taking advantage of a statute of limitations defense? All of those factors play into whether or not there's an adequate statutory remedy at law. And yes, there is not a case that is these exact facts, but that's not surprising. Something like this doesn't happen often. This is not a common thing in the state of Ohio.
Doesn't that get us back to Judge Lansing's question? What the remedy here, assuming we think you're right, we don't have all these facts in front of us. We can't make a decision on whether the equitable remedy is appropriate or not. It's a matter of those ones considered by the trial court. So that's we can send it back to the trial court, please consider.
Yes, Your Honor. I think that, and that was the point of the 56F motion, kind of this acknowledgement of the appellants have tried at every step. We've served discovery, back in fall of 2023. We've kind of been stonewalled, the motion to compel. It's all kind of under the guise of we need these facts to pursue the equitable remedies. I wouldn't think that this panel could just grant equitable remedies, like you said, without the underlying factual basis. But that didn't happen. That wasn't even before the trial court because that discovery hadn't taken place.
If I recall, the trial court denied your motion to continue your time to respond to the summary judgment, but never ruled on the motion to compel specifically. Is that fair?
That's correct. The trial court in one sentence order denied the 56F and never ruled on the motion to compel, by default granted summary judgment, and we presume that as the
But no specific decision where they said I'm not compelling because of A, B, C, and D. They just...
Correct. And as we kind of explained in the briefing, we had to rely sort of on the facts that the city was presenting. They had a self-serving affidavit. We were never able to depose that individual. We asked for communications related to the discovery of this error. We never received them. Lots of privilege objections, yet on a privilege log, just one email. And none of that got to be explored because the summary judgment motion was filed so quickly after the writ decision from the Ohio Supreme Court. So you've kind of got to my second point of the 56F. The appellants believe that the summary judgment decision was incorrect because it didn't properly kind of consider their defenses to the exhaustion, the futility arguments. The city was very clear that it wasn't going to refund any money besides the 1-year statute of limitations. Asking it to do so, they did verbally in a city hall meeting. They were clear in the announcement letter. This is 1 year and that's it. And so an error in not addressing sort of those exhaustion defenses, I would say, and then an error in the lack of discovery in the 56F motion. Just not being able to get to the bottom of the facts due to depositions, due to the discovery, to determine, is this an adequate statutory remedy at law? Based on what we do know, I think the answer is no. If there are no further questions, I'll just reserve the rest of my time for rebuttal. Thank you so much.
You may.
May it please the court, Stephen Funk of Rittman Andrews on behalf of the city of Rittman. This case really is different than most appeals because the legal issues presented in this appeal have already been litigated and decided by the Ohio Supreme Court in the Rittman versus State Equal Rittman versus Spindler case. And in that opinion, the Ohio Supreme Court held that the tax refund claims that are being alleged here, all of the claims, are substantively governed by Chapter Revised Code 2723. And that's regardless of how they're labeled or characterized in the amended complaint. So
Does Spindler deal with the equitable claims? Certainly Spindler deals with statutory scheme 718 doesn't apply, 27 is the right statutory scheme. Did it talk about specifically about the equitable claims?
yes, it does, because what it says is that under Ohio law, there's only two mechanisms by which you can seek a refund of taxes, 718 or 03. And regardless of how these are labeled, now they allege a claim for declaratory relief, they allege a claim under 718.12, they allege a claim under the codified ordinances. Regardless of how they're labeled, they're governed by 2723. That's the Supreme Court's holding. And the Supreme Court had to reach that holding because when we filed our writ of prohibition, the trial court had ruled that they could proceed under 718.12 and under their equitable claims. And we then filed a writ of prohibition saying that no, the court does not have jurisdiction to hear those claims because the only mechanism, if you don't go under 2723, the only mechanism by which you could proceed would be pursuant to the statutory scheme under 718 and 5711. So the Supreme Court had to decide if there are only two methods to proceed, which method applies. And they clearly found that 2723.01 applies. So by saying that, regardless of how it's labeled, the court decided essentially the question. In fact, the court acknowledged that by ruling that way, it would likely mean that their claims would be dismissed on remand because they, by their own admission, did not comply with the mandatory statutory requirement of providing a written protest and a notice of intent to sue. And they don't dispute that they didn't comply with that. So obviously, upon remand, the trial court had a very easy resolution to make, and that was to enforce that requirement. They made the argument that Revised Code 2723.01 doesn't apply to municipal income taxes. There's no merit to that argument. The Supreme Court, in this case, held that Revised Code 2723 applies to these municipal income taxes. And the courts have actually looked at this and applied to any form of tax, whether it even be a licensing fee or some other assessment. So there's no question that this is a very easy resolution, and that's why the trial court's opinion is short. Now, with respect to this question of a remand, I would urge the court not to do that. They did not request a remand. The court has the authority under de novo review to affirm for any reason. And the trial court in this case, the reason is pretty self-evident because the Supreme Court said they must proceed under 2723. They did not comply with 2723 by their own admission, so therefore we're entitled to summary judgment in our favor. It would only result in an unnecessary delay to have some kind of a remand. So I urge the court not to do that in this case, and specifically because it wasn't requested by the plaintiffs in their brief.
But haven't we done that in the past where there's a summary judgment ruling and there's not a burden shifting analysis done with the trial court. I mean, this trial court just referenced a case that wasn't even the claim, a writ of prohibition case that isn't, that aren't even the claims here. I mean, what do we do with that?
Your Honor, I don't think that, if you look at the Supreme Court law, we cited in our brief, it specifically says that the court has the authority to affirm for any reason. So the only reason
But we
why-
typically don't, right, in the Ninth District?
Yeah, I think you do. I think you do. We cite to the Ninth District opinion in our brief. Specifically, though, there's no reason because the court, it's clear, it's self-evident that they did not comply with the statute. So there's no need for a clarification. We know that they cannot proceed based upon the Supreme Court's opinion. So the only thing that would result would be delay and expense. And there would be absolutely no basis to doing that.
Their request for discovery, did I assume did not involve some claim that, hey, we really filed the documents and we don't have a copy of them, so the city must have pleased the city give them to us?
That's correct, Your Honor. In fact, I think she acknowledges that here today. So when you look at the affidavit, the Rule 56 affidavit, it's a conclusory affidavit that says we need discovery in general. There's nothing specific that says we need discovery in order to show that we complied with Revised Code 2723. That was the basis of our summary judgment. That was the basis of our summary judgment motion. So at that point, it's, you know, this court has time and time again said that you can't just make conclusory allegations. You have to say what specific discovery you want to conduct in order to rebut the facts that the opposing parties affidavit. They never asked for any discovery relating to the 2723.03 compliance requirements. And that's a mandatory requirement. The Supreme Court said in Ryan versus Tracy that statute provides the exclusive means. The exclusive means. In other words, you cannot circumvent it and by alleging claims for equitable relief. In Hughes versus Board of Commissioners, for example, 11th District case, same exact situation. They said, well, we don't have to plead 2723 because we're going under equitable relief on just enrichment. The court said, no, Ryan v. Tracy said that's the exclusive means, and you didn't proceed under that statute, so summary judgment in favor of the county. Now, in this case, we have even better. We have more than just Ryan v. Tracy. We have the Supreme Court's ruling in Spittler that specifically says that you have to go proceed under 2723, regardless of how your claims are labeled.
Your client seemed to claim throughout this matter somehow, I don't know how, through affidavit or otherwise, this was discovered in 2022, but yet not hold to the public until 2023.
Yeah.
If in 2022, when they discovered this, they had sent out some kind of notice to the community and said, hey, we've made this mistake over these years. We're going to figure out how to crack this, but we're telling you right now we made this mistake. Would they have been able to make a claim for 2021? Would they have needed to file their notice, protest, and overpayment sometime in 2021?
No, so taxes that would be filed for 2021 would have been due in April of 2022.
So most people would have been prohibited at that point in time because they'd already paid to file their tax without a protest.
That's right.
Only those people that had filed late could have attempted to.
And that's based upon the statute of limitations, not a notice of intent to sue written protest. So there, you know, they say about delay, you know, there was nothing intentional about that at all. It's ultimately irrelevant because the General Assembly created the statutory scheme. So we can talk about, the court can talk about whether it's equitable or not to require notice of intent to sue, but that's what the General Assembly determined. And taxes are statutory, so that's governed by what the General Assembly has decided. In fact, the Supreme Court in Ryan v. Tracy said that specifically that requirement is mandatory and it must be strictly adhered to because otherwise you would be circumventing what the General Assembly provided in the statute. If the court
So would there be a criminal remedy if the government knows they have tax dollars they're not supposed to have and then there's no recourse for them to give them back and then they don't give them back? I mean, so there's no civil remedy, is that what you're saying?
No, the Supreme Court...
I mean in this circumstance.
No, there would not. I mean, the General Assembly determined that the mechanism by which you can get a tax refund is to file a notice of intent, a written protest and notice of intent to sue. If you don't do that, then you cannot get a tax refund. And so with respect to tax year 2022, which is when the error was discovered, they specifically said that we will apply the statute to that tax year. So that was not any kind of error on the part of City of Rittman. They did that as soon as it was discovered. That was when that was the tax year that it could be applied to. So,
and just asking, just from trial court, it wasn't clear to me, and have to the record now, but I think the appellant acknowledges they never filed a claim on Chapter 27. Their initial claim was under 718. They didn't amend to say Chapter 27, even though the trial court said, I think I'm dismissing the claim for they can't proceed in Chapter 27. They've never asked to do that.
Right. What the Supreme Court said, that's right, they did not. The Supreme Court said that regardless of how their claims are labeled, they are governed, substantively governed by 2723. So what he said is, in his order is, you're not going to be able to proceed under 2723 because you didn't comply with the statutory requirements. And that's ultimately what the Supreme Court previewed in their decision. So of course, upon remand, it was a fairly easy resolution for the court. And for this court, for this appeal, the question is, was the City of Rittman correct that they cannot proceed with their claims because they failed to comply with 2723.03? That's the legal issue for the court to decide. The facts are undisputed that they did not comply. The only issue is, can they proceed notwithstanding that requirement? And the Supreme Court said all of their claims are substantively governed by that chapter. So the resolution is very simple.
Well, theoretically, the legal issue, can they in fact comply, proceed with their equitable claim that they've also brought, and you're telling me Spittler said no.
That's right.
They can't do that, and even Spittler didn't say it, Ryan and those line of cases.
Ryan says it's the exclusive means. Hughes, that we cited in our brief, says you cannot proceed. And of course, Spittler says that as well.
And I don't recall that the appellant cite any cases where they say equitable claims can be brought under these statutes and cite any cases that affirm that?
There's not a single one, Your Honor. 2723 in Ryan v. Tracy said is the exclusive means. Exclusive means exclusive. And so the courts have followed that precedent ever since, including the Supreme Court in the Spittler case. They specifically cite Ryan v. Tracy. So, you know, the only issue is, did they comply? And they did not comply, so therefore the summary judgment would be appropriate. With respect to, I want to make a couple other points. This is not a failure to exhaust argument. This is not a failure to exhaust means I need to go through another hearing process before I can bring my claim in court. This is a mandatory statutory requirement that you must comply with in order to bring the claim. So that's not a failure to exhaust issue. So these cases dealing with impossibility or futility are really not applicable at all. In fact, the whole point of, even in the futility context, the courts have said that you can't let the deadline go by and then say, oh, it's futile because now I can't comply. Otherwise, that requirement would become meaningless. And the requirement is that you make the protest at the time of payment. So if you were to say, well, I didn't do that, now I can't comply, then the statutory requirement would become meaningless. So those arguments have no merit. And then with respect to discovery, the motion to compel was moot, because ultimately the motion to compel was not seeking discovery relevant to the issue that was being decided, the legal issue. And so this is very similar to this court's opinion in the Lennon case, which we cited in our brief. Same kind of issue, legal ground for granting summary judgment. And the court, and they argued we didn't get discovery, and the court affirmed because, one, this court has held that the trial court has broad discretion over the filing, hearing, and disposition of a motion for summary judgment. And if you're claiming, if somebody files for summary judgment and you're claiming that you need discovery in order to respond, Rule 56F provides the exclusive means for requesting that. They filed under Rule 56F, but they didn't specifically provide any specific facts. So in Lennon, the court held that the trial court did not abuse its discretion in proceeding to grant summary judgment without discovery, because Lennon failed to show why discovery would have been necessary to respond to the motion. And that's been decided time and time again in Ninth District opinions. And there is no inherent right to discovery. Civil Rule 56B specifically says that we can move for summary judgment at any time. And once we move for summary judgment, the issue will then be, do I need discovery in order to respond to the summary judgment motion, which is what 56F applies. And the trial court has discretion over the regulation of that. And there's no basis to say that there's an abuse of discretion here. If I file a claim and legally it has no merit, I don't get to conduct discovery about that claim. If the court can resolve the question quickly by ruling on the legal issue, the threshold legal issue, that's what the court should do. In fact, that's what summary judgment is for. It's specifically for resolving claims expeditiously if there is a clear, bright line legal reason why the claim cannot proceed. So we ask the court to affirm it's just, again, the legal issues were decided by the Supreme Court. The trial court on remand simply applied the statute as written, affirmed, granted summary judgment in our favor, and we ask the court to affirm. So unless there's any other further questions, I'll conclude there. Thank you.
Thank you. You'll have your full 5 minutes for rebuttal.
Thank you. The city is vastly overstating what the Ohio Supreme Court said in Spitler. The issue before the Ohio Supreme Court was very narrow, and that was, does Judge Spitler have jurisdiction to hear this case? And equitable remedies were not discussed. There was no mention of an exclusive remedy or all of the claims. That's not the quote. The quote is, there were two possible statutory paths in discussing 718 and 2723. What we're talking about here is whether equitable remedies are appropriate because no other adequate remedy exists. And under the city's theory, because a written protest would have to be filed at the time of filing the taxes, and that there's no other equitable remedy available no matter what, under their position, the city could have found out about the error in July of 2022 and not said anything for years and years and years and years, because as long as their residents didn't file a notice of protest, they were just simply out of luck. And the reason why Ohio law recognizes that sometimes equitable remedies are appropriate if there's no adequate remedy under the law is because of issues like this. Now, I'm not saying there was absolutely bad faith, but bad faith warrants fashioning a fair and just remedy. That's when equitable remedies come into play. And to his point of discovery wasn't necessary, well, of course it's necessary. To be able to determine the adequate remedy at law, we have to understand the circumstances surrounding this. Why did it take the city 15 years to discover the error? Did they really discover it in July of 2022? He's saying it didn't matter that they waited 6 months to announce it to the residents. I'd like to see the communications that go into those discussions as the appellants have requested. And so to say that the Ohio Supreme Court has sort of decided this finally is not correct. And Ryan v. Tracy, they did say exclusive means under this statute, but they didn't have equitable remedies that were also being argued.
Do you have any cases that you can cite to where courts have said there's an equitable remedy for payment of taxes after the limits under 1723 or 2723 or 718, any case where they apply equitable remedy over payment taxes?
The only case that I'm aware of involving municipal income taxes isn't under 272301. It's Laborde v. Gahanna.
In that case, you equitable remedies to fashion a remedy for the tax?
No, because they were proceeding under 718. It wasn't part of the discussion. They had a 3-year statute of limitations. The residents in that case weren't arguing there was an inadequate remedy under the law. And to his point, in Hughes, they did put forth unjust enrichment as opposed to the statutory requirement, but there was never an argument that, hey, we're pursuing this equitable remedy because there is no adequate remedy under the law. That discussion just never happened. That is the discussion that's happening here, and there's serious questions about it.
Well, the legislature has chosen a remedy, which is for you to be paid a year, whatever the statute of limitation is, 3 years under certain circumstances, a year under others. That's the legislature's remedy that they apply. Whether that's inadequate if it goes on longer or not is a question for the legislature, isn't it? Not for us.
The legislator did do that, but Ohio law also says if an Ohio statute doesn't afford a party a legal remedy that's appropriate and inadequate, that they can fashion equitable remedies. I mean, that exists as sort of an exception to this case. And if this isn't the type of case that warrants equitable remedies, then I'm not sure which one does. I mean, this idea that these taxpayers are just simply out of luck because the error in interpreting the 1977 tax levy was hidden from them, kept from them, we don't know.
It wasn't kept from them, that's public record. What happened in 1977 was a public record. No one hid anything from anybody.
Oh,
Unfortunately, nobody caught. Theoretically, a taxpayer could have been paying attention for 30 years and said, hey, it's 2008, what do you do? No one did. I'm not blaming anybody, but there's no evidence. They're all public records. Anyone could have known that.
Right, and we would like to depose a member of the city. Maybe it's someone on council, or how did this come about that this discovery happened, and why didn't it happen for 15 years? And maybe that is the answer, but again, we just don't know that.
Well, couldn't there also be some issues with the Constitution with being a victim? I mean, if somebody in the state knew, somebody in the government knew everybody was being overcharged and nobody's getting restitution, I mean, there could be more claims that aren't just civil.
There absolutely could be, and of course, discovery could bear that out. We just have not had the opportunity to do that. So I would just, again, reiterate that the Ohio Supreme Court did not, in Spittler, decide that 2723 was the only remedy. It did not talk about equitable remedies, it did not exclude them, and any insinuation is just not correct. The statutory remedy is not adequate here. And if the trial judge had allowed the discovery to proceed, those arguments could have been borne out. If there are no further questions, I ask you to reverse or remand. Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you again.